Yeah, and it's over now.
It's a week.
But it's old. It's just one.
Exactly.
How are you this morning, Professor?
I've had better mornings.
Yeah, I would hope.
All right. So, thank you to those of you who braved the weather. Welcome. So, unfortunately, due to the inclement weather that scrambled our start, we're not going to be joined by Professor Fry this morning, but we are going to work through, if I can get it to do, we're going to work through Second Amendment cases that you were asked to read for today. So, prior to Heller, we had this argument sort of floating around out there that to the extent that the Second Amendment protected some sort of individual right to own guns, that only guns that you could buy in 1790 mattered. So why does the court call this argument bordering on the frivolous? Mr. Hoy?
They talk about how the Constitution is meant to be adaptable and how new technology shouldn't change really the interpretation that we have on the Constitution. So that the argument that the Constitution, in terms of the Second Amendment, should be limited to things that they had at the time of the writing, but not in terms of First Amendment, like the changing technology of how we express our ideas. It's a non-workable.
Yeah, so the court also makes the point that, right, the Fourth Amendment extends to searches that were not possible in 1790 as well, including the First Amendment case that you point out. And so, similarly, the Second Amendment can evolve in terms of what it protects. Okay? So, court refers to this first clause of the amendment as prefatory. What's their argument for why they don't have to consider it as an independent part of the amendment? Ms. Cobb, can you help us? I'm really glad that was in fact you, because it would have been very embarrassing if I had looked at your face on this screen and gone, oh yeah, that's totally someone else. So,
Because the prefatory clause states why it must be done, and the operative clause states what must be done, and the phrase "the right of the people" and the operative fits poorly. So that's why they focused on the operative clause.
is that what the court says? Well, good job. Give me just 1 second. What does the court actually say about why there's no independent meaning?
Does it have to do with the First, Fourth, and Second Amendment reference?
I mean, I don't know. I'm asking you. So,
I don't know.
okay. So, I'm sorry, go ahead.
Did the court say that the operative clause is not limited in scope or definition by the prefatory clause? Is that why they didn't consider it? Because
No, that's the conclusion they reach,
okay.
right? That's not the reason. So this is a little bit of a trick question, because the truth is the court offers you zero argument for why the first clause has no independent meaning. It just sort of asserts it. Okay? And look, in terms of reading this piece of the opinion, a lot of it's been cut, so it would have been easy for you to go, well, maybe there's something there that we just didn't read. I promise you, no, there isn't. Mr. Dale, right?
Yes.
Mr. Dale is correct about one thing, which is that to the extent that the court offers an argument about the relationship between the two clauses of the amendment, that argument is the first clause can only play the role of clarifying ambiguities. Okay? But the entirety of their argument is because I said so. Okay? All right. So let us assume, for the sake of argument, that we don't buy what the court is selling here. If we don't buy what they're selling about the prefatory clause, does Heller lose? Ms. Morrissey, does Heller lose if we don't buy this assertion that they make?
I mean, I would think yes, just because the prefatory clause focuses on like a well-regulated militia, right? So it would just mean that, I mean, if that clause doesn't matter, then, let me restate that. Would mean if that first clause does matter a lot, then it's mainly focused on, the amendment as it's applying to a militia and, doesn't have any bearing on whether or not he can have a gun just on his person.
So let me ask you this: do you think that the historical evidence that the court musters on the meaning of keep and bear arms, do you find that persuasive as to what those phrases mean?
Yeah, I think so.
Okay. I personally am of the opinion that if you buy what the court is selling about the second clause, that there is something to the question of, like, what work is the first clause doing? Okay? So, I think that if you aren't persuaded by what the court says about keep and bear arms, then I think you're right that first clause becomes really important. And we can see some of that in the dissent from Justice Stevens. But I think that if you grant the court's position on the issue of the historical evidence and on the issue of the reliance interests in the precedent that they dismiss, then everything else kind of follows. But you have to be persuaded by their historical analysis first, I think. Okay? All right. Thank you, Ms. Morrissey. So, both sides of this debate start with citing two dictionary definitions. How persuasive do you guys find that approach? Yes, Ms. Gleason.
I think that it has weight, but then you have to, and they didn't in this opinion. And when you look at dictionary definitions, you can't just look at what today's definition is. you have to look at the historical dictionary definition as well, because they are contemporary. They are updated to the contemporary definitions, and it is a common statutory analysis strategy to use dictionary definitions to find out what the common language, the plain language,
Sure.
is.
Right? But, and I think Ms. Gleason may know where I'm going with this, right? It seems to me that if you are writing what is essentially a persuasive essay, that starting said essay with, according to Webster's International Dictionary, is probably the least persuasive opening I've ever seen. And, starting with the Oxford English Dictionary, just as unpersuasive, but now you sound like a pretentious jerk. But I think that, in terms of what we do in law, I think you're absolutely right that, when we are engaged in textual analysis, it is not uncommon for us to turn to dictionaries as an attempt to sort of figure out what is meant. Now, that is changing as we begin to see something called corpus linguistics become relevant in textual analysis. I don't like it. I don't like it for reasons that don't really have a lot to do with what we're discussing today. But it is out there, and there are judges who get really excited about it. And so, you have to be aware that this is a tool in the kit. Okay. So, court makes this big deal out of the fact that the right to carry arms is intended to prepare individuals for confrontations, right? So what support does this provide for the argument? What support are we getting out of this confrontational aspect?
When you're saying the confrontational aspect, do you mean more of the emphasis on, right to self-defense?
I mean, what does the court say? Right? What does the court say about this in terms of the preparation that carrying arms allows you to do?
Does that have to do with the background of why, how it came from England over to here and why they had that right in the beginning? Because they were scared that they were scared of militias and that the king and queen would overthrow them, so they wanted to have Protestants and give them the right.
I don't know.
To carry arms.
Is that where it talks about it?
They'd mentioned that, yes.
Is that where the court talks about the Second Amendment as being something related to confrontation? What does the court say?
The court quotes Thomas Cooley in suggesting that this is not a right connected to the militia service because the Second Amendment was adopted from the English Bill of Rights of 1688, where it stood to protest against arbitrary action of the overturned dynasty of disarming the people. So it was a protection of individuals, as individuals collectively, against their government. But there's another passage where the court states that it shouldn't be. When I read that one, I lost the other part. But it talks about how it shouldn't be an unlawful or unjustifiable purpose.
I mean, I guess where I'm confused here is that I'm not asking you for. Maybe I'm not phrasing the question very well, but I'm not asking you for like where the court goes and draws on for its sources, right? This is something the court is saying. It's not something that the court is quoting someone on. So what is it doing here, right? What is the court doing? Not what is Thomas Cooley doing, not what is the Parliament of 1688 doing. What is the Supreme Court of the United States doing? Yes.
They're saying that implicit in the words keep and bear arms, there is the expectation that you're using those for the purpose of confrontation.
Right. Okay. Right. So this comes out of the court's discussion of the meaning of bear arms, right? So bear arms becomes loaded for bear, more or less, right? If that's not what bear arms means, then I'm not sure that the court can sort of successfully fend off the argument that there's some specific military meaning of it, right? So in other words, if you don't have the right to confront people with your gun, I don't know what it means to have a right to have a gun at all. Okay? All right. So, now, Ms. Cobb, you have mentioned and discussed some of the pre-independence sources that the court draws on. And it seems to me that the work that most of that pre-independence history is doing is to show that the right to bear arms predates the Constitution. So let's throw it all out, right? Let's suppose that the Second Amendment creates the right to bear arms. Does this change any of the analysis?
I think it would, because then they wouldn't. The weight of relying on English common law wouldn't be as heavy, because the Second Amendment just, what they claim, codifies existing law, right? So if they just created the Second Amendment, it just wouldn't play as important role or significance in interpreting what it means.
I mean, yeah, but do you then come to a different conclusion about what the Second Amendment means? Like, I mean, I agree with you that if we're not drawing, if this isn't something that exists at common law, then yeah, the common law doesn't give us a lot of information about what it means. But do we still, can we reach the same conclusion that the court reaches without this coming from sort of the fount of common law, of our rights as free Englishmen?
I think it's a lot harder to do.
Okay. Why?
Because just throughout their opinion, they reference it so much, and they really focus on our founding and what that meant at the time of ratification, right? And so if they can't focus so much on that, then how can you define, well, let me go back to it. A well-regulated militia being necessary to the security of free state. How can you put so much emphasis on what it meant at that time without those historical references?
Okay.
Right.
I see where you're getting at, and I think that that's I'm not sure that I'm persuaded, but I think that that's probably, I think you've probably gotten me as close as I'm going to get, right? And the reason that I'm not sure that I'm persuaded by this is that most of the rights in the Bill of Rights are created by the Bill of Rights, right? The only exception to this, other than the Second Amendment, is the right to a civil jury under the Seventh Amendment. Because if you read the Seventh Amendment, it says that the right to a civil jury shall be preserved, right? Which is interpreted as meaning that there's something that pre-exists the Constitution, that the Constitution says you are not permitted to change this. And so when we look at, and we are not going to look at the right to a civil jury in this class, but if you did, the analytical framework is very similar in that we're asking what's the scope of the right in 1790, and the Seventh Amendment jurisprudence is like, it's very narrow. The court is really skeptical of arguments that you're entitled to a civil jury under the Seventh Amendment. But these Second Amendment cases take such broad approaches to what is the scope of the right that, like, I just don't see how turning this into something that's created by the Constitution changes the scope here, right? And largely it's because the court wants this to be broad, right? This isn't a situation where like the court is commanded to read this right broadly due to some sort of unambiguous text. You know, this is a choice that they're making, and I see no reason to think that they would make a different choice if we took away sort of their pre-independence sources. Does that make sense? So, okay. Moving on. So, let us suppose that the court makes this assertion: the phrase security of a free state and close variations seem to have been terms of art in 18th century political discourse. In the text that you were assigned, right, the edited version on D2L, they offer no authority for this because I took the authority out. If there's no authority for this assertion, does that seem plausible, what the court is saying here? I mean, to some extent, what I'm asking you here is, like, you know, think back to your undergraduate American history or your high school American history. Like, does this sound like something that might have been said to you in those classes, regardless of whether it was or not? Does it sound like something your teacher might have said? Yeah.
Yeah, I would say that it's still plausible because wanted to answer your question you just asked. Yes, I've heard that term before. But they reference the fact that state is used frequently in lots of different contexts. And so I think that gives credibility.
Okay. Anybody else? Yeah. Okay, so I think that's a reasonable approach. My approach is a little bit different in that I tend to start from the assumption that in a court case, historical facts are contestable. In that, and we'll see this in more detail in Bruin, but courts are not designed to sort of sift through a incomplete historical record and reach the right answer. What courts are designed to do is to sift through a record and reach a final answer, regardless of whether it's correct. Okay? We don't want courts to get things wrong, but we'd rather they make a decision than sit there and go, well, I don't know, until they can make the right decision. So the authority that the court cites to which you were not provided, first of all, it's a law review article, and which means that I'm already going, you sure? Because for those of you who are on law review, as much as I love law reviews and student law review editors, second and third year law students are not historians. And so you are not equipped to necessarily tell when you are being fed bullshit. And the other piece that sort of makes me a little nervous is that the authority is written by a professor who's known for having sort of strong ideological priors. And so when we put those two things together, I do not have confidence that the authority the court relies on sort of lays out the historiographical argument in complete detail and offers sort of the full panoply of evidence. So that's why I'm sort of going, I don't know. But even without that authority, I'm going, I don't know, because this is not something that courts are equipped to do. Okay. All right. So there's a couple of occasions where the court makes reference to regulations of firearm ownership that engage in racial classifications. So what are they doing here? What's the work that is being done when the court talks about this?
Is the court trying to show that although they're trying to show that the right to bear arms was, predated the Constitution, and they're trying to show that there's been restrictions historically, but the right has always been there.
Is that what they're doing? How does that have anything to do with what's being done after? Like, how does evidence of things that are happening after the Constitution comes into frame? How does that have anything to do with what's being with what existed prior to the Constitution?
Can you ask me?
So all of these things here, right? Mm-hmm. State and federal regulations of firearms. These all post-date the Constitution. What connection does this have to proof that the right to bear arms exists prior to the Constitution? Because that's what you said. So I'm trying to understand the logic of what you're saying.
Oh, well, maybe I shouldn't have said that.
It happens. You have nothing to be ashamed of for that.
But
So
I guess they're trying to show that historically the right has been restricted, but it has never been limited to only militia involvement.
So I think there's some truth to that, but specifically, right? Because there's plenty of regulations that the court could draw on that do not engage in racial classifications. So what's special about these, Mr. Hoy?
Maybe they're trying to conflate through the putting front and center of these regulations government overreach and injustice with modern restrictions on gun ownership as well, because they've been used to have these tyrannical sort of impacts in the past.
Yeah, so I think that's a, are you guys familiar with the notion of like, Watsonian explanations and Doyleist explanations for things that happen in texts, right? So the Watsonian explanation is like, it refers to Sherlock Holmes, and the Watsonian explanation is what Dr. Watson comes up with for why something happened, when he doesn't necessarily know the reason. And the Doyleist explanation is, well, what was the author trying to do, right? And so I think you've captured the Watsonian answer, right? That the court is attempting to sort of say, hey, look, you guys on the other side, you're siding with a bunch of racists. And so, if you don't really have a pre-existing strong opinion about gun control, maybe these arguments kind of move you a little bit like, oh, I don't really want to be in favor of that because the folks who did that were not some people I want to associate with. The Doyleist, the more like skeptical, everybody's acting in bad faith kind of argument says that the court recognizes that by sort of opening up the floodgates for gun ownership, the court that they are engaging in policy making that will have disparate negative impacts on Black and brown communities, and so they're trying to sort of like turn it around on the other side, fairly crudely. I mean, you can buy either of these explanations, you can buy neither of them, but that's my best guess for what is, for why the court specifically reaches for these examples, as opposed to any others. Okay? All right. So, when the court is drawing on, like, prior precedent, when it's considering whether prior precedent determines the outcome of the case, they're really dismissive of Cruikshank and Presser. Why? Mr. Harriman, do you have anything for us?
I'll pass for now.
Okay. Anybody else? Mr. Kelsey, can you help us?
I need to pass for now as well.
Okay. Anyone? I'm a little nervous that you guys are struggling with this question because this is probably the closest question I've asked today to like what you guys are sort of being trained to do, which is to analogize from one case to another and to make distinctions between cases, right? So if you guys are having trouble with this, like, we need to step back and think very hard about what we need to be doing together, okay? So, yes, what do you have for us?
Well, so they said in the case of Presser, it wasn't useful because it didn't discuss the meaning or the scope of the Second Amendment, and that's what they were doing, so it was too limited to be applicable.
Mm-hmm.
And then in the case of Cruikshank, am I saying that right? Cruikshank? I
think I've always heard it pronounced that way, so it's
I
fine.
have no idea. They said that I guess it seems like they could have used it, but they just weren't very interested in using it. But the idea was that they think it does support their position because it's addressing the state's police power. So it's obviously outside the context already of a militia.
Okay, I think you're onto something with Presser. I'm not sure what you're saying with Crookshank.
So I guess as I'm reading it, Crookshank was recognizing the state's police power.
Okay, so I mean, you're right that that's what Crookshank is doing, but that's not why the court is dismissing Crookshank as being instructive for this case, right? Specifically, the reason that Crookshank doesn't provide any helpful analysis for this case, according to the court, is that Crookshank limits the scope of the Second Amendment to bearing arms for a lawful purpose, right? So that's where the state's police power comes in, right? That the state has the power to define what a lawful purpose is. But there's no reason to impose that limit if the amendment only refers to militia service, because militia service is per se lawful, right? And Presser, the court sort of says that Presser only tells us that, like, you can't form a private militia. Okay. So, we have not discussed the first, following on from Presser, we have not discussed the First Amendment in this class. So I'm going to purport to you that the First Amendment allows for freedom of association, that I can meet with whomever I like. And this will get complicated, but look, for now, this is good enough. So, doesn't that freedom of association, along with how the court is characterizing the Second Amendment in this case, doesn't it literally give rise to the right to form a private army? Sort of in contradiction to how the court characterizes Presser. Yes, Ms. Gleason.
It depends. I'm
A
sorry.
true lawyer's answer.
Really,
Go
I'm
on.
sorry for that. But if the private army is offensive, then it would be problematic. But if it was,
What if they just smell bad?
well, depends on
Would that
if they
be offensive
intentionally,
enough?
if they intentionally tried to, or if it was just a side effect. No, my point is that the court is really arguing for being able to defend themselves. Individuals to defend themselves. So if a private army was in defense of themselves as a group and someone else was coming at, the government was coming at them, then they would have the right under the way the court's argument is in Heller. But if it's offensive, then again, I feel like it's problematic according to this argument.
So, if you live in a gated community, you can
Neighborhood watch.
you can have an armed neighborhood watch that shoots people who you don't think belong in the neighborhood. Is that what you're telling me?
It has to be more than that. Not just who don't belong, but who are breaking into homes or hurting people. Not just there.
Okay.
It can't just be there.
Okay. Fair enough. All right.
Well, so I don't know if you have the answer to this, but every now and then on the news you'll see there's some event and you'll see like a paramilitary group of guys with guns. And are they, I mean, I haven't heard of cases of those types of groups being prosecuted. I'm trying to understand how they kind of.
So I think that there's a couple of moving parts there. One is, as we know from Presser, right, that there has to be some sort of statute, right? The issue in Presser is whether states are allowed to ban the formation of private armies, not whether they do.
Gotcha.
Okay? And so so the first issue is there some sort of statute that actually does the work that you are looking for? The other thing is there's also prosecutorial discretion. So even if there is a statute, the prosecutor can go, right? So what I will tell you is that if you are persuaded by this logic, sure, like it's plausible to me, but you've missed something. You've not read the opinion closely enough, because at least for now, this argument is foreclosed by waiver. The court says no one has contended that states may not ban such groups. Now, if we sort of step back a bit and go, okay, what happens when this issue is properly before the court? Even if we assume that sort of the logic here is acceptable and sensible as a matter of First Amendment interpretation, I mean, this strikes me as one of those rare cases where you might pass strict scrutiny, right? Whether the state has competition for the legitimate use of force, that strikes me as a compelling interest. I would say that probably banning competing military forces, probably narrowly tailored, least restrictive means, right? Because you can still gather, you can still assemble, you just can't do so under arms. Okay? All right. So, questions so far? Yes.
So I had, and I don't know if we're going to get more into the originalist arguments for both sides in Heller, but I was bothered by, it seems like both the majority and the dissent are agreeing that the Second Amendment was inspired by the fear of tyranny of the government, but they disagree on the victims. So with the dissent, their argument is that the states were the victims. So the issue was federal government prohibiting states from exercising autonomy. And then in the majority, the argument is the fear of the government exercising tyranny against individual citizens' private rights. And my confusion was, it seems like they both make good arguments, and they almost act as if those are mutually exclusive. They can't both be true, and I'm wondering why they can't both be true, because it seems like they both are.
Well, I think what Scalia and the majority would say is that they can absolutely both be true, and the answer is we win, right? I think that you are right that if the dissent is to win, then the majority's characterization of sort of what the purpose of the Second Amendment is cannot be true, right? But even if the dissent is correct, a remedy could still be the majority's conclusion, right? Does that make sense?
Yeah.
I mean, this is something that we'll come to sort of again and again in this class where, like, the court has a stake in convincing you that the text is clear and determinate, and that there is only one possible way to interpret the text, which is the way the court does it. And what I am here to tell you is that that is almost never true in the case of the Constitution. Occasionally it is, right? If you ask me the question, how old do you have to be elected president? The answer is you have to be 35 years old, right? But if you ask me, what does it mean to provide equal protection of the laws? I don't know. And neither does the court. It's all just being made up on the basis of the values that command 5 or more votes at the court. Okay? So does that... I don't know if that helps, but does that at least answer the question?
Maybe. I'm not sure.
Fair enough. It depends. All right. So there's this one particular point in the Heller opinion that I want to draw to your attention, right? So there's an Oregon case that the court cites, Kessler, for the proposition that in the colonial and Revolutionary War era, small arms weapons used by militiamen and weapons used in defense of person and home were one and the same. And the term small arms does not appear in Kessler. Like, there's a reason that it's in brackets up there, and it's because the court has inserted it. And in fact, like, the Oregon Supreme Court describes the weapons used by militiamen and the weapons used in defense of person and home. These are hunting muskets or rifles, hatchets, swords, and knives. So if we take out the term small arms, what does it do to the analysis in Heller?
I think it just makes it less on point than they would like it to appear. I mean, if you just say weapons used by the militiamen, I mean, that could be anything like cannons or whatever, but they're trying to kind of tailor this towards what a reasonable person would have for a lawful purpose. So, you know, small arms makes you think of handguns, maybe a long rifle, but it keeps your mind on point to these things that you might conceivably have.
I think you're right that the addition of this term, like, it matters for applying the rule that they develop to the facts of this case, because the ban that the District of Columbia has is a ban on handguns. There's no, well, to the extent that there may or may not be a ban on long guns in the District of Columbia, that's not before the court, right? What's before the court is the ban on handguns. So I agree with you that if we take the term small arms out, then I think it is harder to apply this rule so that Heller wins. But I don't necessarily think that it matters for the rule that they announce, right? Which is that the right to bear arms is vested in the individual, and that regulations of that right have to meet the same sort of analysis as any other constitutional right, right? So the question of, like, what weapons are covered, the court is right when it says we're going to have to get to that eventually, but I'm not sure that it is necessary for the specific holding of the case. Okay, and just sort of pointing out, right, so this is something I'm going to be doing sort of across, throughout the course, pointing out when the court sort of slides right on by things and doesn't quite make an actual argument, right? So they've said that, there's a pistol as part of the militiaman's loadout, and then they say, well, look, regardless, everybody knows that handguns are what you use to defend yourself. And they don't say how long, and we know by looking at Kessler that at least when the Second Amendment was enacted, handguns were not sort of the go-to self-defense item for average Americans, right? Handguns were things that you took out on special occasions, for things like duels.
Special occasions.
All right. Now I've got sort of a weird question for you, right? The court says the core lawful purpose of the Second Amendment is to enable self-defense. What evidence can we use to determine if someone is using a gun for said lawful purpose?
It'd almost have to be hindsight, right?
I mean, yeah, but like, isn't that too late?
I would say so, yeah.
So, yeah.
You would apply the same framework you would if they didn't have a gun. So if you're attacked, and you're defending yourself, that would be a case where it would be a lawful purpose, presumably. But then you have to look at,
Okay, but then what you're
fear of life.
saying to me is that I'm not carrying a gun for a lawful purpose until suddenly I am.
Well, I guess it depends on when the framework when the analysis becomes relevant.
I mean, you've said, if you're being attacked, right? So that seems to me that, like, if I'm carrying it because I'm right-handed, so, yeah. If I'm carrying it because I think I'm going to be attacked, that's not lawful until I actually am attacked.
Okay, no, I see what you're saying. It has to be lawful beforehand. You have to be intending to only use it for a lawful purpose. So if you're carrying a gun on yourself with the purpose of, murdering somebody, that's not lawful. But if you're carrying a gun with the purpose of yourself and defending yourself against a potential attack, then that will be lawful.
How do I know?
So intent.
But how do I know?
I mean, how we determine intent in any kind of setting, we look at what the person says, and then we look if there's any evidence that would lead us to think that they're lying.
So what do we do? So does this mean that if someone wants to carry a gun, that we should be able to, like, force them to show us all their social media to see what they've had to say for the last year?
Not necessarily. You'd have to have like some kind of like reasonable suspicion to.
Why? If you're carrying the gun, if your intent is to carry the gun for an unlawful purpose, the court says we have the right to say, no, you can't carry it.
Right.
So why can't we determine whether you intend to carry it for a lawful purpose before we allow you to carry it?
Well, it would seem like it would be the issue with any crime you're committing. There has to be some kind of evidence initially.
You're not committing a crime. You're just
right.
You are carrying for an unlawful purpose, however we define unlawful purpose, and therefore you are not permitted to carry. If you carry, then you have committed a crime. But we're just saying, no, you can't carry. But let me just sort of, because I think I think I've beaten this dead horse a bit. So let me let you off the hook, right? As Mr. Hoy points out, right? Until someone uses the gun unlawfully, it's not entirely clear how we get to the point of knowing what they intend to do. And that's pretty much too late. Okay. So, to just sort of wrap this up very quickly for you guys, because the rest of this is about Bruin. So New York has this system of issuing permits to carry a handgun that requires the applicant to show that proper cause exists. And they've interpreted that as meaning a special need for self-protection shown through evidence of particular threats, attacks, or other extraordinary danger. And the court sort of looks at this and goes, well, we have to determine whether this is part of the historical tradition of the United States. And the court says that we have to do this because this is how we interpret every constitutional right, and that is absolute nonsense. that is completely not how other amendments are interpreted. That is Thomas